If you're planning to fly domestically and there's any question mark on your immigration status, a newly public document just confirmed TSA and ICE have been formally sharing travel data, and at least 27 airport arrests have already happened across 9 states. This isn't a new law, and it doesn't mean every immigrant traveler is at risk. But for people with an expired stay or a final removal order they may not even know about, a normal flight could be exactly how ICE finds them. In this video, I'm breaking down exactly what's confirmed, who actually faces the highest risk, who isn't the target here, and the one document you need to check before you ever book a ticket. If your time in the United States may have ended, or you have a final removal order and plan to fly within the country, this update could matter to you. A document obtained by ABC News says at least 27 airport arrests have been reported across at least 9 states. A separate agreement released this week shows that TSA and ICE have a formal system for sharing and storing certain travel data. This is not a new law, and it does not mean every immigrant traveler will be arrested. But for some people with an expired stay, a final removal order, or another serious case issue, a normal flight may make them easier for ICE to locate. In this video, I will explain what is known, who may face the highest risk, who is probably not the main target, and what you should check before you travel. As of July 30th, 2026, the newest part of this story is the public release of a written agreement between the Transportation Security Administration, known as TSA, and Immigration and Customs Enforcement, known as ICE. The agreement was signed in May 2025. It became public on July 28, 2026, after a public records lawsuit filed by a watchdog group called American Oversight. That date matters. The agreement did not begin on July 28th. It had already been in place for more than 1 year. What changed this week is that the public was able to see part of the written plan behind the work between TSA and ICE. The agreement says the two agencies may exchange agreed data for national security, travel security, law enforcement, immigration, and border work. It also sets rules for how some data may be stored and managed. But the parts that appear to list the exact data fields are mostly hidden from the public. This means we know the system exists, but we do not know every detail about what is shared, how often it is shared, or every rule used to select a traveler. ABC News also reported that at least 27 arrests took place at airports through this tactic. Those arrests were reported across at least 9 states, from California to Virginia. But the document did not say when all 27 arrests happened. So this number should not be called a one-day total, a one-week total, or a full national total. There is another number that needs a clear explanation. Reporters said in April that TSA had given ICE records linked to more than 31,000 travelers from the start of the current Trump term through February 2026. More than 800 arrests followed TSA tips during that period, but reporters could not confirm how many of those arrests happened inside airports. This difference matters. The 27 number refers to reported arrests at airports. The 800 number refers to arrests that followed TSA information even when the later arrest may have happened somewhere else. Saying that more than 800 people were arrested at airports would go beyond the facts now available. Here is how the system worked before. TSA used its Secure Flight program to check passenger details for travel safety and government watch lists. ICE already had the power to arrest some people with final removal orders or expired immigration status. ICE did not need this new public release to gain that power. What appears different is the method used to find some people. A flight booking and airport check can show that a person plans to be at a known place at a known time. This can give ICE a faster way to locate someone whose name matches a record in its system. TSA and ICE also have different jobs. TSA screens travelers and works to protect the travel system. ICE enforces immigration law inside the United States. TSA does not approve a green card, decide an asylum case, or issue a final removal order. USCIS decides many immigration benefit cases. Immigration courts decide many removal cases. Customs and Border Protection decides whether a person may enter at a border or airport after an international trip. Now, let us look at the first group that may face the highest risk. This group includes people with a final removal order. A final removal order means the government has reached a legal point where removal may be carried out unless a court or agency has placed a valid hold on that action. Some people know they have this order. Others may not know. A person may have moved, missed a court notice, or failed to attend a hearing. In some cases, the judge may enter an order when the person is not there. This is called an order in absentia. A person may be able to ask the court to reopen the case, but filing a normal motion to reopen does not always stop removal by itself. There are special rules for certain orders entered after a missed hearing. Because the rules are not the same in every case, a person should not assume that filing one paper has made travel safe. The second group includes people whose approved time in the United States may have ended. This is where many travelers become confused. The date printed on a visa is not usually the date that controls how long you may stay after entering the country. A visa lets you travel to a United States port and ask to enter. After you arrive, the period of stay is normally shown on your Form Y-94 or another official approval. The Form Y-94 may show a set date for some students and exchange visitors. It may show D/S, which means duration of status. That normally depends on the person continuing to follow the rules of the program and immigration class. Imagine a visitor named Daniel. This is only an example. Daniel has a tourist visa that looks valid until 2027. He thinks that means he may stay in the country until 2027, but his Form 194 says his approved stay ended on June 15, 2026. Daniel plans to take a domestic flight in July. He looks at his visa and feels safe. But the visa date does not answer whether he may still remain inside the United States. Daniel needs to review his form, his I-94 later filings, and every approval notice. He may have filed a valid request that affects his case, or he may have a serious overstay problem. The answer depends on his full record. This example shows why one date can change a travel choice. It also shows why you should not copy another person's plan. Two people may have the same kind of visa, but very different Form Y-94 dates, court records, and pending cases. The third group includes some people with pending immigration cases. A pending case can mean many things. It may be a family petition, a green card application, an asylum case, a request to extend a stay, or a motion in immigration court. These papers do not all give the same protection. For example, filing or approving a family petition on Form 113 does not by itself give the person legal immigration status. A work permit shows that a person may work for a set period. It does not by itself erase an old removal order or fix every past status problem. A pending green card case may affect a person's legal position, but the exact form, filing date, entry history, past court case, and any old order still matter. A BC News reported that some people detained in airport cases had work permits or parole papers. That does not prove that every person with those papers faces arrest. It shows why one document cannot tell the whole story. Before I walk you through exactly what to check before you book a ticket, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. Now, let us be clear about who is probably not the main target of this update. United States citizens are not visa overstayers. A lawful permanent resident with a valid green card and no removal issue is not in the same position as a visitor whose approved stay ended. A person who is keeping valid status and has no final order is also in a different risk group. Still, no report can promise that a traveler will never be questioned or delayed. Names can be similar. Records can be wrong or old. The full data fields used in the TSA and ICE agreement are not public. Anyone with a complex history should review the facts before travel. There is also an important difference between domestic and international travel. A domestic flight normally takes you from one place inside the United States to another. You are not asking to enter the country again, but travel data from that booking may still help ICE find a person. An international trip adds more issues. Some people with pending green card cases may need advance parole before leaving. Some may risk giving up a pending case by leaving without the right travel paper. Departure after more than 180 days of unlawful presence can also lead to a 3-year bar in some cases. Departure after 1 year or more can lead to a 10-year bar in some cases. These rules have exceptions, and not every day is counted the same way for every person. That is why leaving the country in a rush may create a new problem instead of fixing the old one. Do not make a major travel choice based only on fear, a short video, or a post on social media. The Daniel example can also show the real human cost. Imagine that his mother in another state becomes sick. He wants to fly to help his family. His reason is caring and honest, but a kind reason does not change the dates in a government record. Daniel checks his papers before buying the ticket. He learns that his visa date and Form Y-94 date are different. He also finds an old court letter that he did not understand. By asking a qualified immigration lawyer to review the full record, he gets a clear view of the risk before reaching the airport. Careful planning does not promise a good result, but it can stop him from making a choice based on a false belief. Here, our goal is to turn hard immigration news into clear steps you can use. The first step is to check your Form Y-94. Read the name, passport details, class of entry, and approved end date. If it says D/S, make sure you are still following the rules tied to your school, exchange program, or work category. Next, place all your immigration papers in date order. Review your passport, Form I-94, USCIS receipt notices, approval notices, work permit, parole papers, court notices, and any old order. A receipt proves that an agency received a filing. It does not always prove that you have status or that an old order has stopped. You should also find out whether you have ever been placed in immigration court. Check every hearing notice and decision. If you moved, make sure the court and the right immigration agencies have your current address. Missing a notice can lead to a missed hearing, and a missed hearing can lead to a serious order. If you may have an expired stay, a final removal order, a missed hearing, a past removal, a fraud claim, or a criminal case, get personal legal help before buying a ticket. Ask the lawyer to review the full history, not only the newest work permit or receipt notice. A Department of Justice accredited representative may also be able to help through an approved group. Keep safe copies of your key papers. Leave copies and the contact details for your lawyer with a trusted person. If children, older family members, medicine, or work duties depend on you, make a lawful family plan before travel. If an officer approaches you, stay calm and do not fight or run. Do not use false papers or give false facts. Do not sign a paper that you do not understand. Ask which agency the officer works for. Ask whether you are free to leave. Ask to speak with a lawyer before making a major legal choice when that right applies. Now, let us correct a few common claims. Some posts say every immigrant who takes a domestic flight will be arrested. That is false. The reports show targeted data sharing and targeted arrests. They do not show that every visa holder, student, worker, green card applicant, or lawful resident is being arrested. Another claim says a valid visa stamp proves that you are allowed to remain in the United States. That is also false. The visa date and the approved period of stay are different. For many travelers, the Form Y-94 is the key record for the time allowed after entry. A third claim says a work permit or pending family case makes an airport arrest impossible. That is not correct. A work permit gives permission to work. A family petition can prove a family link. Neither paper by itself answers every question about status, court orders, or removal risk. There is one more number-based rumor to correct. More than 800 arrests followed TSA tips through February 2026, but available reporting does not prove that all of those arrests happened inside airports. The separate document reports at least 27 airport arrests and does not state the full-time period. Keeping these figures separate is the honest way to report this story. The balanced message is not that every non-citizen should stop flying. It is that some people with a known status problem or final removal order should not treat a domestic flight as having no immigration risk. The new public document confirms formal data sharing between TSA and ICE. Recent reporting also confirms real airport arrests, but the full matching method remains partly hidden, and the reports do not say that most immigrant travelers are being arrested. Do not panic. Check your own record. A friend's safe trip does not prove your trip is safe. Another person's arrest does not prove you will be arrested. Your own form, I-94, court history, filing record, and legal facts matter most. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.